At this point, let's bring in an expert on this. We are joined by international law expert, Attorney Ross Tugade. Attorney Tugade is also an accredited assistant to counsel at the ICC. Good evening, Ms. Tugade. Thanks for joining us today.
Good evening, and thank you for having me on the show.
I know you don't have a lot of time, so I'll cut to the chase, Attorney. What do you think of the submission on the merits of the case so far by the defense counsel?
Well, when we go to the defense counsel's arguments, and I've said this elsewhere, that it seems that Mr. Kaufman in his submissions was trying to make the argument that there was no intent on the part of Mr. Duterte. When it came to the utterances, that actually did not mean that he meant to carry out the criminal plan or the common plan as it is denominated in the charges. But in my own assessment of how he argued that point, in the ICC or in the statute of that established the ICC, the Rome Statute, it's not only the pronouncements that are being assessed, but also what happens behind closed doors, so to speak. What are the ways in which they organized the system? What were the kinds of planning involved in terms of implementing the common plan?
That's also one of the backbones, well, the main backbone of Attorney Kaufman was that there's no causal link here between Duterte's words and the killings on the ground. In fact, he said there's no smoking gun, and certainly he's trying to make the case that there is no common plan. He says it all collapses at the level of the so-called perpetrators because there's absolutely no proof, no single piece of evidence that he did directly order such killings. What did you make of that?
Well, first of all, when it comes to the anti-drug policy of the Duterte administration, there is a lot of paper trail, an official paper trail at that even at that level that speaks to how the common plan was actually implemented. We have a number of memorandum circulars that covers Oplan Tokhang and the double barrel operation of the government, the HVTs and the Oplan Tokhang, which constitute the different counts of the charges that were formulated in the document submitted by the OTP. So, with respect to that argument that there is absolutely no evidence of a common plan, I think that is already belied by the fact that there's a massive paper trail that shows us the description of how Tokhang and HVTs would be carried out.
The documentary evidence here is what? Police reports mainly?
Police reports could be one of them. Police reports can actually tell us about the pattern. So this is also something that I have been emphasizing in other places that I have spoken, that the pattern will constitute those non-repeating, non-coincidental types of acts that constitute the criminal design over, let's say, a geographical area or a span of time. So police reports can definitely tell us more about the context, the pattern, the modus operandi, which is a more familiar term to us. But more than that, when it comes to the structure, we have the command memorandum circular, which contains that very contentious word that they have been debating about in the past 2 days, the word neutralize.
Yeah.
And again, we can infer from how neutralize was being interpreted through the implementation of the plan that neutralize would result into the killing of drug suspects.
And yet, repeatedly, Attorney Kaufman made the point that to neutralize does not mean to kill directly. It means it pertains to lawful law enforcement operations, and the fact that the killers on the ground, the police operators on the ground, interpreted it to mean to kill is on them, not on Duterte.
Yeah. Under the framework of the Rome Statute, it is actually not, it's not required or not needed to be proved that, in this case, the indirect co-perpetrator, if that's the mode of liability that we're pinning on Mr. Duterte, would have made a legal assessment first of the actions that he carried out or his participation in the criminal design. So there's actually no requirement for him to make the legal assessment. So I think, in my assessment, that argument that basically says, well, it was all framed through self-defense, that the orders to the policemen would be to subdue the drug suspects, but within the ambit of self-defense. That I think is quite a red herring of an argument. What we need to focus on is the pattern of criminality that sufficiently fulfills the specific elements of crimes against humanity of murder, as well as the contextual elements of crimes against humanity of murder, which is the widespread or systematic attack against against a civilian population. And in the elements of crimes read together, it says any civilian population. It does not require to make a distinction as to a segment of the population.
So you're saying in international law, and especially at the ICC, there doesn't have to be a proven direct link, because the idea that you have to prove, the prosecution has to prove a direct link keeps coming up. And in fact, earlier this afternoon, we spoke to Attorney Sal Panelo. As you know, he was one of the 6 lawyers sent by the Duterte family to the ICC to observe at this point the hearings. And he repeated to us that he believes that this case should be thrown out, because if you base it on the merits of the case, there is no evidence here. And certainly he believes that the direct link should be proven by the prosecutors. So you're saying that is not the right interpretation?
What I'm saying here is that when we try to establish causality, so causality is actually needed to be established in any criminal case, even in domestic criminal cases, you have to show causality. But I think what they're trying to say is that, well, we don't have any evidence that any of his speeches actually said, kill them, or it did not actually prove that he was the one who was actually ordering, or he was the one who basically carried out the criminal acts. What I'm saying is, when it comes to the framework of the Rome Statute, there are different modes of liability by which a person can be found guilty of crimes against humanity. So at this level, we're not yet adjudging the guilt of Mr. Duterte, just sufficient enough evidence for it to proceed to trial. And in the case law of the ICC, there's the mental element. Okay, there's the mental element that Kaufman was also trying to allude to, that requires, aside from intent, it's also that virtual certainty. So virtual certainty is actually enough in the case law of the ICC to establish liability for certain criminal acts within the jurisdiction of the court. So virtual certainty is enough for us to assess liability, in this case as an indirect co-perpetrator. But remember, there are also other modalities that are being alleged, aiding and abetting, as well as ordering.
Correct. So virtual certainty, not necessarily that you have to draw that direct link, that line has to be proven first. Could you also weigh in on one of Attorney Kaufman's arguments that this is not a crime against humanity, because the targets were a subjectively defined subgroup, meaning they are drug pushers, they're users, they're not, i.e. general civilian population, that the killings were random and not systematic, and certainly that they were not state-sponsored. What did you think of that?
So going back to the text of the Rome Statute, it says widespread or systematic. So what separates those two words is the word or, which means in the alternative. So it could be widespread, it could be systematic. So that's on the first, what we call the chapeau element or contextual element of crimes against humanity. Now, on to his argument that it has to be a distinct sector or a distinct part of the civilian population. I was quite surprised that Mr. Kaufman was trying to make this argument because he knows very well, as an expert of international criminal law, that we make these distinctions as regards the identity of the group in other crimes like genocide. In war crimes, it matters if it's civilian versus combatant. But for crimes against humanity, which is a very distinct case or a very distinct crime under the framework of the Rome Statute, read that with the elements of crimes. It says any civilian population. So that level of making a discrimination or discriminatory intent as to the segment of the population you're targeting, that's not required in crimes against humanity, as opposed to, say, genocide, that requires you to target certain groups based on certain types of identity or identification.
Okay, I wonder why that he saw fit to bring that up. I guess. I'm not a lawyer, so I can't hazard a guess. But last question, Attorney Ross. What do you think? Well, actually, no, I'm not last question because I misread the time. I do have a little bit more time for you. But what factors do you think will carry the most weight in the judge's decision at the end of this week on whether or not to push the case forward to a full-blown trial, to dismiss it, or to ask for more evidence? Which of the factors that you've heard so far will carry the most weight, do you think?
I think the contextual elements are key here in establishing that it is a crimes against humanity case. With respect to the specific elements of murder, I think we've already gone past the point of trying to prove that several people or a lot of people were actually killed in the context of the drug war. So we've already hurdled that legal threshold. When it comes to the contextual elements, I think that would be key in how the pretrial chamber would decide whether or not this would proceed to the trial proper. So they have to assess if there was widespread or systematic attack. They have to gauge the common plan. They have to also look at the nature of the attack, as well as what we call the linkage evidence or the actual participation of Mr. Duterte as a perpetrator, whether that's indirect perpetration or aiding and abetting or ordering in the whole criminal design.
It's a real delicate balance that they have to weigh here. Titimbangin talaga yung mga arguments on each side. What about the idea that the witnesses that the prosecution presented are not really credible, as Attorney Kaufman has been alleging? He says, they are, giving all these testimonies just merely in exchange for immunity. He says they made wild assertions about the drug war under Duterte, and he says that a lot of the so-called DDS, the Davao Death Squad, is a fictitious thing, and because particularly because no witness has come forward to say that they directly heard Duterte give a kill order. What did you think of this tactic of discrediting the witnesses?
Again, it surprises me coming from an expert of international criminal law that he has introduced these kinds of arguments in his submissions. He could have attacked the widespread or systematicity of the common plan. He could have attacked the nature of the attack that was being alleged, or even the mode of liability. But here, it seems that going the route of discrediting the witnesses is something we don't usually see in this kind of proceeding or in this very high level of international litigation. So I was quite surprised that he's going that route, and that route is quite a familiar trope for us Filipinos, something that we hear of in our own domestic legal system, but that's not something that we usually hear. In the ICC, there have been cases of witness intimidation, and the court has promptly responded to those instances where there were cases of witness intimidation. That's governed by a different provision of the Rome Statute. So I'm waiting what the court will make of these allegations by Mr. Kaufman.
Would it work, do you think? Has it ever worked in the ICC, this tactic of discrediting witnesses?
What I could say is that so I hazard to make a speculation on this, but what I would say is that the ICC is by design is very big on procedural fairness, especially for the perpetrators. So due process rights are a big thing in the ICC. So when it comes to weighing those kinds of allegations, I think the ICC will have to look at them carefully. They will certainly scrutinize, but also factor in the reality that the Dutertes are still a very powerful family in the Philippines, and they do have certain access to resources and power that you don't normally see in an ordinary criminal investigation.
Yeah. Last question, Attorney Ross. I know you have to go. Not related to today, but I'm sure you've heard as well this week that there were allegations that have come up that the ICC investigators that came to the Philippines were quote-unquote wined and dined and even bribed to a certain extent. So much so to the point that at some point the ICC spokesperson's office had to issue a statement, denying all of these claims because I heard that they were being bombarded by so many Filipino journalists. Maybe give us a sense of how they operate, right? Because I think a lot of people still believe this narrative that they were bribed.
Yep. So just looking at the kinds of crimes that the ICC has under its jurisdiction, these are crimes of a massive scale, usually perpetrated by an organization or a structure that has access to power, has access to resources. So it's always quite difficult for investigators to go in country and do the investigation so out in the open. So again, I am also quite baffled by these kinds of allegations that the investigators were receiving cushy treatment in plush hotels or restaurants. It's really quite difficult for them to enter active contexts where there is a lot of possibility of intimidation on the kind of work that they are doing.
And indeed, part of the statement, I looked it up again, part of the statement reiterated that the costs related to the investigation, including mission expenses, are fully covered by their own budget, and everybody's covered under an independent oversight mechanism. So we wanted to just re-emphasize that. Okay, we'll leave that there. Thank you so much for talking to us tonight and for all your insight. That was very helpful. That was international law expert, Attorney Ross Tugade.
Thank you.
Thank you so much, ma'am.